Greetings, everyone. Peace and love. Once again, I'm Richard Taylor. I'm coming back with a video concerning the Wayne County Sheriff Department and the investigation thereof by the Federal Bureau of Investigations. For about 2.5 weeks, I've been sharing information, doing videos concerning the arrest of a couple of deputies and the investigation of one deputies, and also other stories surrounding different people's experiences with corruption and the judicial system. Now, once again, since I've been doing this, various individuals have reached out to me and shared numerous accounts and various documents of substantiating the claims of what many people think is a corrupt department that goes all up not only to police but also to judges, lawyers, and things of that nature. So what I'm going to do now is I'm going to shift the concentration to the judges, to the district attorneys, to the defense counsel, and various other players, because there's no way for anyone to think that two bungling cops like Cox and Worth could pull off these elaborate schemes without the help and the assistance of others. So an individual reached out to me last night, and we're going to be meeting Tuesday. They have a very close relationship with the courts and the inner workings of the things like that. So they're going to be sharing some information, some documents with me. So I'm going to share those with you confidentially. Nevertheless, before I do that, I wanted to give my own experience and give people an understanding. Like, I just didn't wake up one day and said, okay, all police are corrupt and the justice system is inadequate, and distrust anything associated with the criminal justice system. That's not how it happened. These my views and my skepticism of law enforcement, the judicial system, comes from years of experience. And actually, in hindsight, I didn't realize this until my first book, but it started when I was 8, 9 years old, and my mother was rushing us back to choir rehearsal at Tabernacle of Prayer on John Street, and she was coming down the hill on Bunch, and the police officer was hiding. If anybody knows that in the late 80s, early 90s, they would always hide on Bunch Street before you get down the hill, because the hill naturally made people go faster. So they would hide there and stop people. And that one particular day, they stopped my mother without going into the details of the stop and her interactions with the police. My mother left that interaction crying, bawling out because she had got a speeding ticket. And right then and there, I developed, I guess, a vitriol or oppositional nature towards authority, because think about it. If anybody makes your mother cry, my dear mother, who never committed a crime in her life till this day, if anyone makes her cry, of course, they're not going to be my friend. They're going to be my enemy. So I think it started from there. And nevertheless, the numerous other incidents that I write about in this book, Blue Lights in My Review, that detailed so many interactions that I had with law enforcement, the judicial system, and things like that. But I want to touch on one particular instance, and I'm going to try to be brief with that, to just show you how the court system, the DAs, the judges, and the lawyers, the defense counsels, especially the court-appointed attorneys, all work together to keep this system running like a fine oil machine, and the end goal is never justice. Now, I'm going to share this with you, right? It was actually 10 years ago today, September the 17th. If this was 2013, I would have been sitting in a Norfolk City, or I was, not would have been, I was sitting in a Norfolk City Jail, Norfolk, Virginia City Jail, on the 7th floor amongst murderers, rapists, killers, shooters, people facing 50 years, people are already sentenced to 100 years. I'm in the cages with those individuals, right? And I'm charged with rape, kidnapping, abduction, abduction with intent to defile, sexual assault, and about 2 other misdemeanors, right? And I'm gonna just deal with the court aspect of it. Now, if you want to get the whole story, this is the book that I wrote about that experience. Wrongfully Accused, Rightfully Acquitted. You can get that directly from myself. But nevertheless, just let me walk you through this process, and I'm gonna try to be brief, right? So I get arrested on June the 1st. June the 1st, 2013. Now, I go through the whole arraignment process. They appoint me this court-appointed lawyer. I'll never forget his name. His name is Jeffrey Halleck. And I would have put his face in the thumbnail, but upon researching and looking him up, I found out he recently passed. And so out of respect for the deceased, I won't put his picture up there. But nevertheless, I was assigned Mr. Halleck. And, after the initial arraignment, they assigned him to me. He said he would come up to the jail and speak with me the next day, in which he did. Now, in the Norfolk 7th floor, the attorneys don't come up because, of course, it's too dangerous for them to come up. So what they did was take me into a little room, and they had a screen with the phone, just like if you ever been on a video visit, as they call it now. So I pick up the phone, and he comes on. He's downstairs in whatever room he is. So he's doing like this. He never once looks up at me. He never once looked up at me. He goes through the generic questions: your name, where you live, do you work, this and that. And about 2 or 3 minutes later, he never asked me what happens, and he said, "Okay, well, I'll get in touch with you." I said, "Well, don't you even want to know what happened?" And he finally look up at me and said, "No, I'll talk to you later. I have to go now." Click up. And he hung up the phone. He hung up the phone, and the screen went black. So now I'm thinking, man, I don't have a chance, right? I don't have a chance. So time goes on, and it's time for the preliminary trial hearing. Now, the preliminary hearing is when your lawyer, go up, and then the prosecutor and the quote unquote plaintiff, and I say quote unquote plaintiff in this case because the whole thing was a lie, but nevertheless, they come up and they present evidence, and you present evidence to see if this case actually needs to go to trial, right? So before that night, before the preliminary hearing, Mr. Halleck comes up to the jail again, and he said, "Well, we have a preliminary hearing, but they've offered you a plea agreement. They've offered you a plea agreement." And I looked at him with frowned up face, like, "What are you talking about?" I didn't even say nothing because he just kept talking. Well, if anybody knows lawyers and court-appointed lawyers, they're good with the quick talk. Well, they've offered you a plea agreement, and I think it's a really good one. But only thing you have to do is waive the preliminary hearing, and they've offered you a plea of 27 years. And only thing you have to do is waive the preliminary hearing. And right then, I realized that, this guy is not in my defense, right? So I said, "Mr. Halleck, I did not do this." And I told him, I said, "You don't remember me, do you? You don't remember me." I said, you didn't even ask me what happened when we talked the first time. And I said, "As a matter of fact, you hung up the phone on me." And he looked at me again, picked his head up from his papers, and said, "Well, actually, I got to go now too. See you tomorrow in court." Click up. Now here I am, once again, facing the rest of my natural born life in prison for something I did not do. And this court-appointed lawyer has yet to ask me what happened in order to try to defend me at the preliminary hearing. So he doesn't know any questions to ask this person to prove that she was lying, right? So I decided in my mind then that I am going to defend myself tomorrow because he knows nothing to ask that would prove my innocence. And that's what I did. I realized once again, in hindsight, these lawyers, these court-appointed lawyers, I'm just a number of many of their cases. So their goal is to get me out of the courts as quick as possible. And the only way to do that is the plea agreement, right? So we go to court that next morning, and I tell the judge, I'm not going to go through the whole hearing, but I tell the judge, I say, look, I don't have any doubt of Mr. Hallett's capability to represent me, but he has not asked anything of what happened. So I feel that it is in my best interest to, represent myself today and, ask the questions and present evidence of myself. And first thing, the prosecuting attorney or the district attorney, she just immediately objected. No, he has not passed the bar. He hasn't He is not, he is making a mockery of the court. She tried to pull that angle. And so the judge looked at me and he said, well, unfortunately, Mr. Taylor does have that right. He's in sound mind. I don't think it's in his best interest, but, he's allowed to do that. And if he needs any assistance, he has his counsel right there. Long story short, I performed I think I performed good amidst all of the objections of the prosecutor trying to rattle me. I knew that there were certain questions that I would be able to ask this woman that would prove amongst the receipt of certain documents or certain evidence that, the whole thing was a farce and she was lying. So I get back to the cell. Now, this is August. This is August. Yeah, so it's August. And so I have a month to go. Now, when you're facing a charge, you have a right to obtain what is called the motion of discovery. And that is all of the evidence that the state plans to present at trial so you can defend yourself. And so that's all the witness statements, the testimonies, the witnesses they're going to bring. You have a right to know all those things so you can see what they're doing and how you can disprove their case. So now at this point, after the preliminary hearing, I instantly start calling Mr. Hallett's office. Hey, I need the motion of discovery. And every time, actually, I never really spoke to him. I kept speaking with his secretary. He never answered the phone. And I always called after court hours. So there was always this deflection. And so I kept asking him for the phone records, which, because of my questioning in the preliminary hearing, I knew that they would prove that she was lying. I asked for the DNA records. I asked also for the preliminary hearing transcript so I can pull to the transcript and prove everything that she was saying was a lie in comparison with the motion of discovery, which were all her testimonies and things like that. Nevertheless, a month and a half goes by and I receive none of that. None of that. It's always a deflection. Well, we're not able to get the phone records. We're not able to get the DNA records. The motion of discovery hasn't came yet. The transcript for the preliminary hearing hasn't came yet. I kept getting this runaround every day, every week. And so one day I'm laying in my cell and I hear my name called. I think it's about the end of September now, right? So now my trial date was set for November the 4th. And so now it's the end of September, and the bailiff or the CEO calls me up and say, "Hey, Taylor, you got court this morning." I'm like, "I ain't got no court, man. What you got going on?" I said, "Man, your name was on the list." I said, my court date is not until the 4th. And so the man, he said, man, you got court. So if anybody's ever been in jail and you got court that day, you know what that means. You got to get up at 4 o'clock in the morning. You got to get dressed, get changed, get searched. You got to go down to the holding cell in Norfolk. You know, the jail was separate, so we had to go in the holding cell and wait. Then we had to get transported to the courthouse, get dragged down on the chain gang to different cells and wait. And so your morning lasted for about 6 hours on cold hard benches with bologna sandwiches. So that I did not want to go to court that day because I didn't know what it was for. So finally, when the time came for me to go to court, here comes Mr. Halleck in, and he says, I said, what? I said, what's going on? He said, well, we're going to ask for a continuance and things, and you know what I'm saying? Because some reason I was like, no, I do not want a continuance, and I'm gonna explain that to you next. But I said I do not want a continuance, and I said, look, man, I didn't do this. You haven't even asked me what happened, and this is the response. He said, sometimes you just got to get a little rough with them, hey. And I said, man, what are you talking about? Now, mind you, other people are in the cell. So if you know anything about jail, you don't, rape is the most despicable crime among inmates. So you don't talk about, that if that's what you're facing. And that's what I had to do. And also because in Norfolk City Jail, as well as probably many other jails, they had something called hopping on your case. Now that means if somebody saw you or overheard you talking about some details of your case, they would actually call the DA or call their lawyer and say, hey, I got some information about this case that he said this, that, and the other. And then next thing you know, when you go to court, this gentleman is on the stand against you, telling you something that you said or he made up in order for him to get a lighter sentence or for him to get on his case. So I stayed mum the whole 5 months. But nevertheless, I told him, I said, no, I don't want to continue because I had also did study. So now when you're in jail without a bond, you have a right to a fair and speedy trial. And in Virginia, that those number of days was 150 days, basically 5 months. Now, the only way that your right to a speedy trial is null and void, it is if you, as the defendant or your counsel, agree to or request a continuance. That is when your right to a speedy trial is null and void. And that's what he was trying to do because, of course, if he would have did that, I'd have sat in there for 2 or 3 years as they continued it and continued it and continued it until they wore me down and I'd have took a plea for something I did not do. So all you gentlemen out there who are in jail facing without a bond or even with a bond and you're facing a serious charge, never agree to a continuance if you know you didn't do it or you know you got a chance of beating the case. Never agree to a continuance because that negates your right to a fair and speedy trial, and they can keep you in there for years, as y'all probably seen that happen many of times, and there's nothing anybody can do because you've negated your right to a speedy trial by agreeing to a continuance. So, and when he said that, when the lawyer, gave that statement in response to my not wanting continuance, I decided right there that I was going to fire him that day in court when we got in front of the judge. And so when we get in front of the judge, the lawyer presents the request for continuance, and the judge he looked at the paperwork himself, and I think he might have remembered me. He was like, nah, this guy is not, going for anything. So the judge said, well, nah, because the continuance, and they wanted to continue it to January, which would be beyond the 150-day precedent for me to obtain a fair and speedy trial. So the judge was like, nah, because this gets into, the fair and speedy trial rule, so I'm not going to grant this request. And so, but also, I raised my hand. I say, look, Judge, I don't, why? And once again, I gave my disclaimer I have no doubt about his capabilities, but I don't think he's efficient. He hasn't asked not one question about what happened and how to defend me. So I want to fire my attorney, and he said, "What is so? You want another attorney?" I said, "Yeah." So he said, "Okay, I want to grant your request." And he looked on his paper and said, "Okay, Mr. B. Thomas Reed." Mr. B. Thomas Reed was sitting on to the side, and Mr. B. Thomas Reed, he was assigned my case. But what once again let me know that why this lawyer was acting like that. This lawyer, after the judge hit the gavel and it was taking me back, this lawyer looked at the prosecutor, the one who was trying to convict me. He looked at her and was like, "I'm sorry, he wouldn't let me do it." That's what he said. He told this lady he was sorry he wouldn't let me do it. I wouldn't let him do what? I wouldn't let him railroad me. I wouldn't just sign a plea. I wouldn't allow him to just do the minimal work for him to get the trial and him not defend me. Like, I can just imagine what that trial would have looked like if he was my lawyer, because he never did any due diligence on my behalf. So I get B. Thomas Reed. And when I go back to the cell, I tell some of the guys, "Look, man, yeah, man, I had to fire my lawyer. I got B. Thomas Reed." As soon as they heard his name, he said, "You got Reed? You got Reed? Oh, he's a beast. He's a beast." So I was like, okay, I start feeling good. So the next day, no, matter of fact, it was the same day. Mr. Reed came up. He didn't call me on the video. He came up and went into the little room that I was, and me and him are sitting face to face, no guards or anything, and we just talking. I'm telling him what happened. He's writing everything down. He's telling me about his daughter who overdosed. You know what I'm saying? I'm telling him about my books. I'm telling him about everything, because I'm literally crying out like, "Look, man, I did not do this, bro. I'm not trying to spend the rest of my life in prison for something I didn't do." And so at the end of the meeting, which lasted about an hour, maybe an hour and a half, he said, "Okay, we'll be fine." And I told him everything that I needed. I needed the motion of discovery. I needed the pre-trial hearing summary, the preliminary hearing summary. I needed the DNA records. I needed the phone records. And don't you know, within the next week, I had all of these documents right here in my set. And I found this box the other day. But these are the phone records, the testimony, the preliminary hearing, all of our statements, the DNA stuff. I'm talking about, I got this full package within a week. All of the things that Mr. Halleck said he couldn't get, in his office said he couldn't get, Mr. Reed provided for me within a week. So I got the information. I was able to go through all the call logs. I was able to go through all the testimony. I was able to go through all the evidence, circle things that were inconsistent, certain things to prove that the story was a lie. Long story short, I handed it all to him, and he pretty much he said, "Mr. Taylor, you miss your calling. You should have been a lawyer, because I don't have to do anything. You definitely pointed out all the ways that this story can't be true." So we get to court. Now, this is the last part I'm going to tell you about. If you guys want to read the entire, once again, story, you can get this book, Wrongfully Accused, Rightfully Acquitted. But the morning of the court, the morning of the trial, right, before I go to trial, before they even pick the jury, I'm sitting in the cell. My mom done brought me a suit. I got the suit on. I got this thing on my leg that doesn't allow one of my legs to bend, just in case I try to run, because when you're in a trial, if you have on handcuffs and things, of course you're going to be biasing the jury. Nevertheless, so I'm in there pacing, reading scriptures, praying. I prayed like I never prayed before in my life. That's when I really got closer, knew how to pray, got closer to God. But Mr. Reed came in there. He said, "Mr. Taylor?" I said, "Yeah, man, how you doing?" He said, "I'm all right." He said, "Well, they've offered you a plea agreement. And once again, here's another plea agreement right before we supposed to pick the jury and everything, right? And so he tells me, he said, well, she's agreed. Now, this is the same DA that painted me to be a monster just a couple of months earlier in the preliminary trial. Painted me in front of the judge to be this monstrous, rapist, despicable animal in front of this judge, right? But now it's time for trial, and she says, my lawyer says, well, they've agreed to drop the rape. They've agreed to drop the kidnapping. They've agreed to drop the abduction. They've agreed to drop the abduction with the intent to defile. They've agreed to drop the sexual assault. Only thing that you have to do is plead guilty to felony assault, and you'll walk out of here today with time served. Now, mind you, I had been in there for 5 months and 3 days. Well, no. It was probably like, it might have been about 4 months and, about 2.5 weeks. So I looked at him, right? And I asked him, I said, why is she agreeing to do all of this? And he looked me right in my eyes, and excuse my language, but he said, because he knows it's bull crap. But he didn't say crap. He just said, as a matter of fact, he knows it's bullshit. You know what I mean? And so I was like, well, Mr. Reed, I can't take the plea. And the reason I couldn't now, if I wouldn't have already been on probation, I was already under an 8-year sentence from when I got shot. I had drugs at the scene, so they charged me with the drugs, and I was on an 8-year probationary sentence with an 8-year probation. So just that simple conviction, if I would have pled guilty, it would have been an automatic violation of my probation, and I wouldn't have got out of jail anyway. I would have been stuck fighting, this probationary sentence. So I told him, I said, well, no, I can't take that plea. But I said, that's great though, right? Because we can use the fact, that she just offered to release me in our defense, right? If she offered me a plea to release me, that means, we can use that in our defense, showing the jury that, this woman just agreed or was going to let me out before this case started. So that means, why would she be telling you all of this? He was like, nah, we can't use that because that goes against the quality of ethics. He mentioned some type of legal term, but I was like, that's not, that's not searching for justice. You know what I'm saying? The jury should know that she just tried to release me before she gets up there and paints a picture of me of some murderous, kidnapping, abduction rapist, right? He said, nah, we can't mention that. And that one thing right there let me know that these lawyers, and especially the DAs and judges, they are not out for justice. If that prosecutor knew that the charges and knew from the evidence that the girl was lying, her duty as a purveyor, as a seeker of justice, should have been to automatically release me. Instead, what did she do? She said, okay, well, he's been in there 5 months. If I agree to drop everything and I get one conviction, that's going to go under my belt. That's one notch higher, that I'm going to move up. So instead of releasing me, because she knew I didn't do anything, she would rather have me agree or plead to something I didn't do and still be released. But with that, she gets a conviction. And that's what these lawyers, these judges, these district attorneys are only interested in is conviction. Think about it. The only way you move up is what? For a prosecuting attorney, more convictions. The only way you move up and sustain your time as a judge is what? More sentencing hours. So this is something that should not be when we're in the search for justice, where people get incentives for people going to jail. So the whole thing is not set up to seek justice. You know, they say Lady Justice is blind. Yes, he's blind to the underworking, to the backhand, underhanded operating measures of these district attorneys and these lawyers. Just like that lawyer said, in my case, he wouldn't let me do it. You know, and he was more emboldened, or he was more loyal to the prosecutor than he was to me in his actions, because he never once asked me what happened, but all he did was bring pleas from the district attorney, which would have, you know, I would have been still sitting there with about 17 more years to go if I would have been knowledgeable. And the thing is, so many of our people, I'll say, you know what I'm saying, because in Norfolk jail, it was only, you know, it was mostly black brothers in there. So the thing is, most of our people don't know the laws and don't know their rights to be able to fight these things with some sort of effectiveness, with being granted counsels like this. Because long story short, you know, at the end of the trial, it was last of the week, I came back, I was found not guilty on all charges. I was exonerated fully. And when I got back to the cell, you know, every day when I would go out with my evidence and with my Bible, and you know, the guys would be, all right, man, you taking it to the trial? So scared, you know, you taking it to the trial? You taking it to the trial? Every day I come back, how did it go? How did it go? How did it go? So the last Friday, that Friday when I came back, they asked me how did it go. I was like, not guilty. You know what I'm saying? So then everybody grabbed their paperwork from one of their books and was like, hey man, look at this, look at this, look at this, look at this. And a lot of them, you know, a lot of the cases I looked at within my, you know, like 4 or 5 hours for them to process me out, if they would have taken the proper steps, you know, they probably, you know, could have beaten their case with the jury trial. Now, most of them, once again, in Virginia, there was something called a bench trial, when you just say, okay, the judge is going to be my jury. So you got the defense attorney, you got the prosecuting attorney, and then you have the judge. And all of them are deciding your fate. And I'm like, man, how stupid can you be to put your fate in the hands of this judge when he works lock, stock, and barrel with all three of them? Do you really think you have a fighting chance? You know? And he gets paid, he gets promoted, he gets incentivized on how many sentencing years that he gives. Do you really think that you have better chance? But that's what these court-appointed lawyers were advising all of them to do. Because, of course, a jury trial takes time, takes money. It costs, you know, all of the money that it costs to put together a jury trial. But, I mean, I learned so much in my 5 months. In that particular situation, not to mention all the other situations that I've encountered. But that one situation right there let me know, man, if you don't have a sound mind, but also a lawyer who is there to uphold the legal and the moral and the ethical values that are precipitated in the court system and in his oath, it's not the Hippocratic oath, but it's some kind of oath they take, I guess, to be, you know, to be a lawyer. If they're not holding those values, then you are up the creek without a paddle or a boat in this. So this is just something to let you know that this is not nothing that I've heard. This is, you know, DA corruption, lawyer corruption, judge corruption. This is not something that, you know, somebody had to write and tell me about. No, I experienced this firsthand. So that's why when people come to me with claims and evidence, I'm not going to dispute it. I'm not going to doubt it, because, you know, if I didn't go through this, if I didn't experience this firsthand, people will probably doubt the story that I made. Like, if I didn't have, you know, all of this documentation of, you know, the things that I went through, you know, people may doubt some of those things. But this is real life, man. This is these people. Little Johnny from up the street, his uncle knows the judge, and when he goes to jail, he's immediately released. And when he goes to court, they're going to meet at the country club, and they're going to say, Johnny's going to get probation, and I'm going to give you this donation for your foundation, and little Johnny is going to be off. But when it comes to my man Raekwon, who gets caught, on the block for the third time, and he has no connections with Judge Waynesworth, or, and that's hypothetical. But and he goes in there with no advocate. He can't afford a lawyer. He has no connections with the courts. Then he gets the habitual felon sentence of 7 to 10 years for getting caught his third time with about $100 worth of crack in his pocket. Like that's the end all be all of crime. And we're going to get into. I want to address really the futility of this war on drugs, because that is once again a farce to usher in people in the judicial system. But also we have to examine the difference between the crack epidemic and the opioid crisis. You see those two? You see how they sound different? But I'm going to get into that. But this is just a video for a precursor of the information that I'm going to share on Tuesday about the inner workings of, once again, these lawyers, these defense attorneys too. Everybody knows about Charles Gurley, and his activities, and once again, we're not to believe that he's the only one who's out here buying and using drugs and taking drugs for payments and all those things, allegedly. Let me say that. But and also these district attorneys who once again are involved in some things, as well as the judges, and who have these backroom deals that we don't hear of, but we all see the repercussions of as well, or the ramifications of those actions. So I hope once again this has been informative of letting you know who I am. And that happened once again in 2013. And that there's so many more instances I can tell. I may be getting some of those later on. But if you want the full story, you can call me directly, 919-587-7782. I'll let you know how to get these and all my books. But, that's just one instance that gives you an insight of how and why I know that these things that, some of the people are telling me are definitely fathomable, if that's the word. But I'm going to be out. Y'all have a great night. Peace and blessings. Y'all tune in, I think, tomorrow or Tuesday. I'm supposed to meet with the lady. So I'll be able to share some more information about this Wayne County, as one person told me, this good old boy network of law enforcement and criminal justice and the entire judicial system. But y'all be blessed. Peace and out.